Step 4, are there any debts or creditors? You need to evaluate and pay creditors' claims. Now, what do I mean by creditors? Creditors typically are people that are owed money by the decedent, maybe for hospital care, medical care, credit card bills, that sort of thing. Let's say it's a mortgage on the house. That's what we call a secured creditor. And regardless of whatever creditors processing you do, they already have a security interest in that house, and you're not going to get rid of that creditor claim, or that debt rather, because they're already a secured creditor before death. Let me just take a little aside right here, going back to the situation we talked about. Maybe you inherited that house and there's a mortgage on it. A lot of people get concerned. It's like, oh no, I'm going to have to refinance. Interest rates are really high right now. No, you don't. There's a federal statute called the Garn-St. Germain Act. And what it says is if you inherit the home and it's got a mortgage on it, you basically inherited the mortgage. The mortgage company needs to keep it with you. You don't have to refinance it. You don't have to go get a new mortgage. You now are the person responsible to pay the mortgage because you now own the property. So that's a little aside to tell you, if you inherited property with a mortgage, you don't have to refinance it. And do you want to? Well, it really depends on what the interest rate environment looks like. So high interest rates, no, you're not going to want to refinance it. Low interest rates, maybe you will. Talk to your financial advisor about that. So let's talk about the typical creditors that a decedent's estate has. Oftentimes it is credit cards. So what do? Remember, you went through all of their mail. You saw the monthly credit card statement come in. Then you want to give an actual notice to that creditor to say, here, if you've got a claim against this estate, you have to bring it according to the laws. And if they don't do so, if they miss it, if the credit card company doesn't do it right, you don't have to pay them. It doesn't matter if it's a $2,000 debt or a $20,000 or a $40,000 debt. If you did the notice properly, the credit card company didn't properly do their part, they are out of luck, period. That might be one reason you want to work with an attorney, to make sure you do it properly. There's more that I could say about creditor claims and how to extinguish those, but that's probably a subject for a different discussion on a different day. Give notice to the actual creditors, and also publish notice in the legal newspaper in the county where the probate is, or in the county where any real property is, to say, if you are a creditor of this estate and you don't know about who they are, I don't know about you, but if you're a creditor of the estate, you have 4 months to bring a creditor's claim. And if they don't, then they are out of luck too. So this whole creditor's claims process is to make sure that if there are legitimate debts that must be paid, they will be paid. If there are debts that you don't know about and the creditor doesn't bring a claim, they're not going to collect from you as a personal representative from the estate. And if there are claims that are in dispute, that they're going to be resolved. So you're making sure that whatever the assets of the estate are that you've gathered up, that you've tallied up, that you've totaled, that when it comes to, bringing to a conclusion the probate, you're able to distribute them without worries that somebody later is going to come back and being the creditor is going to come back and say, no, you shouldn't have distributed all that because I'm a creditor and I should have received it. You want to make sure that that doesn't happen. Protect yourself as the personal representative and the beneficiaries who are going to inherit. Make sure that there aren't any creditors. That's done through the creditor's claims process, which includes giving actual notice and publishing notice in the newspaper. So that's a really important part of the probate process, and it's a huge benefit to it, as well as to extinguish creditors' claims. I mentioned this before. It's worth mentioning again. Don't forget about the IRS. They are actually what's called a super creditor, which means you got to make sure you pay them. You're not going to get rid of their claims. So work with the accountant. Make sure that if there's any taxes, personal taxes due, like income tax liability, that it's paid. If there's any estate tax that is due, that it's paid. If you live in Washington, our estate tax level is 2.193 million. What that means is that if your estate is worth less than that, there's going to be no estate tax paid. If your estate is worth more than that, and that money goes to people and to not charities, then there will be an estate tax that is paid by the estate. So make sure if you're working with a larger estate that you're working with a CPA. Likely, if you're working with a larger estate, you're working with an attorney too, to make sure everything is done correctly. If you are a married person, a married couple, there's different rules that the IRS has about when estate taxes are paid. So you're definitely going to be wanting to talk to a CPA and a lawyer to ensure not only that estate taxes are avoided, but future estate taxes are avoided.